Hello, everyone. Happy New Year. Welcome to our January webinar. Um, Today, our speaker is attorney Cathleen Summers, and she's going to be talking about common estate planning mistakes and how to avoid them. Now, I would like to introduce Kathy. And she is Kathleen Summers, and she will be our presenter today.
Thank you, Allie, very much. And I want to introduce you to everyone. For those of you who don't know, Allie Jesse is been with us since when? About September of last year, Allie, is that right?
April. Can
Oh,
you believe
April.
it's
Oh my
been
goodness.
April?
Oh my goodness. I'm even losing track of time. But Allie has been an incredible new addition to our marketing department, and we're thrilled to have her. So, Allie, thank you so much for the introduction this morning. Issues there,
Thank
but
you.
Happy New Year to everyone. Cannot believe it's already January 21st. We're already almost through the first month. But want to talk with everybody today about common estate planning or common mistakes that we make in estate planning and how to avoid them. So we're going to go through really kind of 7 areas in terms of common mistakes within estate planning. First of all, we're going to talk about not having a plan at all and how that affects both for you while you're alive and certainly after your passing. A big one is about forgetting to update beneficiary designations, and I'm going to talk a little bit about that and some steps you can take now and each year to make sure that your beneficiary designations are correct. Not planning for incapacity, that's a huge one. For those of you who are clients of ours, you've heard us say that, planning certainly for what happens after you die is critically important, but even more important is planning for what happens while you're still alive, and in particular, if you should become incapacitated or incompetent for any reason. DIY, estate planning disasters. I'll talk a little bit about that with you, becoming more and more of both an issue and a concern. It's an opportunity, but it's also a concern, making sure that those do-it-yourself documents out there are the correct documents and that they're properly done and properly executed. For those who have a trust or think about putting a trust together, one of the biggest things we see is improper or incomplete trust funding and how that affects your estate plan. Ignoring tax implications. Massachusetts has an estate tax. Usually that's a bigger concern for us than the federal estate tax, and I'll talk a little bit about both of those limits and how we can make sure that we're paying attention to not only estate tax issues, potentially other issues like income tax concerns, capital gains. And then the last but not least, not communicating your plan with family or other loved ones and how that can lead to big issues and big concerns after your death, and certainly while you're alive if something happens to you and you can't manage things yourself. So let's begin with the one about not having an estate plan at all. They say that, if you fail to plan, you plan to fail. And that's really true when we're talking about estate planning. The problem is that when you die intestate, which means that you don't have any kind of plan like a will in place, then the state and the court's going to decide what happens with any assets that you have left. Here in Massachusetts, we tend to have laws that talk about taking care of your next of kin. And those may not be the people, or particularly if you were someone who had any kind of charitable desires, you're not going to be taking care of them. And so you want to make sure that it's really clear within your estate plan who you want to benefit by anything that you have left. So leaving it to nothing is going to end up that the state laws end up taking over, and they're going to control how things pass after you die, and they're going to control who's going to be managing your estate after you die. So some of the real-time conflicts of not having an estate plan are certainly family conflicts, that you end up with wrong people in positions such as guardians or other decision makers like personal representative to manage the estate. There certainly can be asset delays in terms of making sure that your loved ones have access to funds and can be able to take care of themselves and any kind of bills, et cetera, that may come due, and unnecessary taxes. We'll talk a little bit about the estate tax and how planning for that helps, but tax consequences are definitely something that come into play. So one of the big things to think about if you haven't started with any kind of planning yet is to start. Just start with the basics. At the very least, you want to make sure you have a last will and testament in place, again, to help us to manage what happens with your asset holdings after your death, and to have what we call the competency documents in place, your power of attorney, and your healthcare related documents, so that if something happens to your ability to manage things for yourself, you've been able to designate the people of your choosing to step into your shoes. One of the big things, and we have a blog coming out this month on this as well, is forgetting to update your beneficiary designations. So oftentimes we forget that certain assets, 401ks, 403bs, any kind of IRAs or life insurance policies, oftentimes annuities, have named beneficiaries. And these named beneficiaries are going to supersede anything that you may have written in a will or a trust. So they pass outside of a probate proceeding. They pass outside of your will. They pass outside of your trust. And so making sure that you double check each year at the very least your beneficiary designations to make sure that they're lining up with who you want to receive those assets upon your death is critical. So one of the things we see is when life changes happen, such as a divorce, remember to make sure that you've updated the beneficiary designation on any of your assets like 401ks, retirement plans, life insurance policies. Also, if a loved one has passed away, you want to make sure that you have updated and made sure that their name is removed as a beneficial designation. If you don't have designated beneficiaries on an asset, they're going to end up passing through your probate estate. And so you may have a trust in place, but you have a retirement plan in which you have not named a beneficiary. That retirement plan is going to be subject to probate, even though you had something like a revocable trust in place during your life. This is really critical to make sure that the people you want are properly identified. It's also critical to make sure that the people's names are properly spelled, that in some instances that we're clear about what their relationship is to you, so that at the time of your death, when the beneficiaries go to claim their interest in the asset, that they're able to do so without much hassle, not having difficulty and, oh my goodness, the name was spelled incorrectly, or somehow they're not able to be clearly identified as the beneficial interest in that particular asset. So make sure that you take a look at your beneficial designations on all assets that have them, that you make sure that they are properly identified, and that you understand that they are not passing per the rules of your will or the rules of your trust if someone is named specifically as the beneficial designee. And certainly after any kind of life changes, divorce, death of someone, a loved one, a birth, etc., you want to make sure that you're updating those beneficial designations. There are also some specific rules here in Massachusetts around beneficial designations for certain retirement plans. In certain circumstances, you must name your spouse if you're married, or you have to have them agree to the change in beneficial designation. So work with your different financial holders to make sure that you follow the rules around who you can name for beneficial interest. One of the big things I talked about is that, again, we oftentimes focus on planning for after we have passed away, but failing to plan for incapacity or incompetence becomes a huge issue. Oftentimes I'll have married couples come in and say, well, we jointly own everything. Can't we just manage things for each other? Well, for certain assets you can, like jointly held bank accounts. Those things, if you're an owner of, you certainly can manage those accounts. However, other jointly held assets, such as property, cannot be managed by one or the other without the agreement and consult of the other and their willingness to participate and ability to participate in planning for that asset. So it's really imperative that you do planning to make sure that you're taken care of and you've named who you want to step into your shoes should you not be able to manage things for yourself. One spouse cannot manage things like the 401ks or retirement plans for the other without authority to do so. So making sure that you have updated powers of attorney that have enough authority in them to be able to allow the person that you've named as your attorney, in fact, to manage these assets on your behalf is critical. A family can't access any of the accounts, can't make medical decisions without having authorities in place. So powers of attorney, healthcare proxies, things like living wills, your HIPAA authorization and release forms are absolutely critical to have in place to ensure that while you're alive, you're able to have the person of your choosing stepping in to make decisions for you. Very much an overlooked aspect of planning when we focus so much on what happens after we've passed away. Remember, if we don't have these kinds of documents in place ahead of time and something happens to your ability to be able to manage things for yourself, we end up having to turn to a court, and we oftentimes have to go through a proceeding to have a guardian appointed for things like medical decisions or to have a conservator appointed for handling your financial world. Those are expensive proceedings to go through, and they involve court actions and court participation, and you do not want to go down that road if you can help it. You also end up not having any control over who gets appointed to be your guardian or conservator in most cases. And so making sure that you've planned ahead of time for incompetence or incapacity is an absolute critical point. Let's talk a little bit about DIY estate planning. It's becoming more and more of a thing that, particularly with the introduction of AI and its use these days, being able to, or thinking, I can go ahead and do estate planning for myself. Well, in some cases, there are certain forms that you might be able to do. Things like a healthcare proxy. Now, the one that we tend to do with clients gives a much larger breadth of authority, but there is a one-page document that allows, at the very least, for you to be able to appoint someone who could step into your shoes for healthcare decisions if you need that to be in place. And so having something in place is better than having nothing in place when it comes to healthcare decision making. And certainly forms that we fill out in our doctor's offices, like HIPAA forms and things like that, can be a form of DIY that you could use. But one of the things we always say is that if you've worked with a professional and you have put documents like healthcare proxies, HIPAA forms in place, use those, because every time that you update your healthcare proxy, you have the risk that you have now revoked any previous documents that you may have put in place, and you may also cause confusion. If you haven't named the same people in all of those documents, it may end up causing more confusion in the end as to who would be your decision maker should something happen to your competency or capacity. The other thing that we see with DIY estate planning is that oftentimes people don't choose the right forms or documents to use. Can you put together a revocable trust for yourself online? Yes, probably you can. There are lots of software programs, et cetera, that could put that together. But knowing why you're using a revocable trust, understanding what types of language is needed in that kind of a document to ensure that your goals are clear and to make sure that what you want to have happen happens. It's critical to make sure you work with someone who understands those documents and can put them together for you so that they really reflect your wishes. Oftentimes what you see on a DIY situation is that it's a very canned approach and it may not deal with the specific nuances of your situation. Another reason that we don't, or that we worry about DIY documents is sometimes they're not executed properly. Each state has specific requirements about how a document should be executed, who it has to be executed in front of, witnesses, let's say, how many witnesses, whether it needs to be notarized or not, whether the witnesses' signatures need to be notarized or not. And in understanding all of that is critical to make sure that the documents are valid. Because oftentimes, particularly when we're talking about documents that might deal with competency or capacity issues, if you become incompetent and now that document has to be used for the person of your choosing to be able to step forward on your behalf and it's not valid, you now have wasted your time in trying to put it together, and you don't have the person of your choosing being able to have the authority they need to be able to move forward. And you're going to end up in court, or they're going to end up in court trying to get authority over you so they can do what they need to do. So there are sometimes that DIY documents can be helpful, particularly something like a healthcare proxy in an emergency to make sure someone has been named to be able to step into your shoes. But most times we caution people against them because they really can cause more problems in the end than not. One of the common things we see in a DIY document, for instance, is there needs to be specific authority here in Massachusetts to handle the sale of real estate. So, in a will, if you own property at the time of your death and things are passing through your probate estate, the will has to explicitly give the personal representative the ability to manage that property. If it doesn't, then we have to get additional court authority, which takes both time and money in order to be able to get what we call a license to sell. So just a small thing like the failure to include specific language in the document can end up having a costly effect on the estate and cause a delay in terms of the administration of that estate. So DIY has its place in certain instances, but be very careful and make sure that you are sure that that document is that it reflects what you want and it's going to be accepted as a valid document if it needs to go into play. Here's a huge issue that we have and we see often is that people have, let's say, a revocable or revocable trust in place. Very common type of trust. You also sometimes may know them as living trusts, and beautifully written documents. They do exactly what the person has asked them to do and reflect what their wishes are. But there's a failure to actually fund that trust. You don't put your assets in the trust. I know for our clients, we give them what's known as a funding instructions letter that talks about how to get assets transferred into the trust. Now, the problem is that if you don't properly or completely fund your trust, then at the time of your death, that trust is not going to do everything that you wanted it to do. Number one, you're not going to avoid probate. So if there are assets that are still in your name at the time of your death, and they don't have a named beneficiary, or they're not jointly owned with someone else, they will be subject to probate. Where had you put them in your trust during your life, the trust could manage them and no probate proceeding would be necessary. Now,
Kathy, we have a question in the
sure.
chat box that pertains to this. The question is, can you name your trust as the beneficiary in your insurance policy?
So you can. You certainly can name the trust as a beneficiary for many different things, but you want to make sure you understand what the potential consequences are for that. So oftentimes what we say is reasons for naming your trust. You have specific language or specific beneficiaries named in the trust that you want to ensure, let's say, equally share the proceeds from that policy. Or you have a beneficiary who might be a minor or someone who has some kind of special need, and you want to make sure that their share of that life insurance policy in this particular case is going to be held in ongoing trust for their benefit. Giving it to or naming it the trust as the beneficiary allows you to ensure that that happens. But other assets, it may cause some complication, like retirement plans. There are different payout rules for a retirement plan that is left to a trust as opposed to, let's say, being left to a surviving spouse. It is always better to leave it to the surviving spouse, or in most cases, I should say, it is better to leave it to the surviving spouse than to a trust vehicle. But yes, a trust can be named as a beneficiary. Just make sure that you're doing so purposefully and you understand what the consequences are for that asset flowing through the trust as opposed to going to a named beneficiary or beneficiaries directly. So I hope, if that didn't answer the question, please let us know. But again, when we have trust, making sure that they are funded with all of the assets that we can put in them is critical in order to make sure that we have really gained all the benefits of that trust. Another thing about trust, and I'll talk a little bit more about this when I talk about tax consequences, is oftentimes when we are dealing with spouse trust, a husband and wife, we've got a revocable trust, either two of them, or we have one joint kind of family revocable trust. Another benefit of those trusts than just avoiding probate is that they often have tax language in them that allow us to be able to take advantage of an estate tax savings or a potential estate tax savings when the second of the married couple dies. Now, if we haven't funded the trust completely, then we might risk losing some of that estate tax benefit upon the death of the second. So it is critical that if you have this type of trust, that you make sure that you have completely funded that trust to take full advantage of both the avoidance of probate and the potential estate tax savings, particularly in the married couple situation. So check one of the things very much like the beneficial interest, take time to take a look at your assets. These are your investment accounts, savings accounts, checking accounts, individual stock holdings that you might have, certainly real property like real estate. Make sure that they are properly titled, they've been transferred into your trust, that your trust has been identified correctly so that the name of the trust matches the name of the titling of the asset as well. And oftentimes we also have a date that goes with that. And the date is the date that the trust was originally created. So sometimes we'll have clients who come in and have updated their trusts over a period of time. Maybe they've restated the terms of their revocable trust completely. We always go back to the original date that the trust was first put together in order to identify that trust, even if you've changed its terms multiple times over the years. So you want to make sure that all of that lines up, and if you have any questions, always talk with your attorney to make sure that it's done correctly. And look at that annually, just as you do with your beneficial designations, just to make sure that everything is in there. Sometimes we've added a bank account during the year and we forget to put it in the name of the trust, or we've bought new property and we forget to put it in the name of the trust. So definitely check that out as part of your annual review.
We have another question involving
Sure,
trusts, Kathleen. The
sure.
question is there a benefit to putting property in a trust to help avoid the federal look-back laws or for other tax advantages for the beneficiaries?
So the question's a little bit confusing to me. So if we're talking about the look back with respect to Medicaid planning, so this is long-term care planning, when someone wants to apply to the state to pay benefits, when we're talking about that and the look back period, a revocable trust is not going to help to protect that asset. Remember, revocable trusts are ones that are for your benefit as the creator of the trust, typically, oftentimes yours and your spouse if you are married. And so the assets in a revocable trust, because they're for your benefit, don't have any protection around them. Assets in something like an irrevocable or irrevocable trust are different, and those are subject to a 5-year look back. Allie, can you read that question again? Because I think there was another part of that.
Yes. Is there a benefit to putting property in a trust to help avoid the federal look-back laws or for other tax advantages for the beneficiaries?
So the tax advantages that we see for the most part with revocable trust is to take advantage of the estate tax situation and potential reduction when the second of a married couple dies. So right now, the federal estate tax limit is about 13.99 million, so most of us don't have to worry about that. And we see that for the majority of the clients, that's not something that it comes up as an issue. It's really the Massachusetts estate tax, and I'm going to talk a little bit about that now, that we try to take advantage of. Let me explain a little bit. If we have a married couple, and this is really where we see this advantage come into play, and we don't do any kind of tax planning. So the first spouse passes and everything passes to the survivor, whether it's because you've jointly held all the assets or because you have a will that leaves everything to your surviving spouse. We won't have an estate tax levied when the first dies, but if when the survivor dies, and they have all of the assets in their hands at that point, and the asset value is more than $2 million, we may have an estate tax issue. And right now, we're really, in Massachusetts, it's for the value over the $2 million level that's subject to the estate tax. It's a graduated scale, anywhere between about 6 and 16%. Most people come out at around 8 or 10%. So if you have a $2.2 million estate, it's about $200,000 that's going to be subject to the estate tax, or you're going to have about a $20,000 tax bill. It's a very simplified example. How we use trust is we take that same $2.2 million estate, and what happens with the first dies, again, we have no estate tax due because it's the first of the married couple to die, but the trust has language that allows us to capture typically about half the value of the estate. So in this example, about 1.1 million. In this case, that value is still available for the survivor of the two, but when the surviving spouse dies, that first 1.1 million is not subject to the estate tax. And we have reduced, and now in this case, we've eliminated completely the Massachusetts estate tax, because all that is left for the survivor in their name is the 1.1 million. So we look to try to minimize taxes where we can, and if possible, completely eliminate them with respect to estate taxes here in Massachusetts. And we have to do that through something like a revocable trust in order to take advantage of the exemption that the first to die gets. If we don't take advantage of it through the revocable trust, then we've lost it. We don't have any portability here in Massachusetts, and so when the second dies, they don't get to claim the exemption for the first to die unless they have done trust planning ahead of time. So ignoring tax implications is the next big mistake, not thinking about how estate taxes might affect an estate when the second of a married couple dies, and not taking advantage of how we might be able to reduce the risk of estate taxes. Now, anyone who has met with me will know that I say that Uncle Sam gets his taxes one way or the other. So, there's always going to be some form of taxes to pay. Oftentimes it's income taxes that we may have to look at, capital gains taxes. So things like a revocable trust definitely help to avoid the Massachusetts estate tax or help to reduce the exposure to it. But we always want to look at what other potential taxes may be there. And so one of the things that we always recommend that people do as they're going through their estate planning is that they might sit down at this point and really talk with someone who might do financial planning with them as well. If you're heavy in things like retirement plan savings, there might be some opportunity to be able to look to, let's say, convert some of those plans to Roth IRAs, pay income tax now, where you might have deductions and things against it to help reduce some of your income tax exposure, as opposed to leaving those IRAs and paying the full income tax when you begin to take your minimum distribution. This is, we spend so many years saving and building things like our retirement plans, which is wonderful and an excellent way of helping to save for retirement and what your needs may be in the future. But you always want to take a look at, are there opportunities to be able to take advantage of something like conversion, being able to look at how you're managing your asset holdings a little differently, particularly when you go from working to a retirement stage, and help to reduce things like an income tax exposure. So some of the things that we do with estate planning is really take a look at, can we help to reduce or eliminate the particularly Massachusetts estate tax exposure? And then talking with you about working with someone like a financial planning professional to see what could be done about retirement plans, let's say, to help reduce income tax exposure, capital gains exposure in the future. Every year, again, you should take a look at this, just like you do with your trust funding and with your beneficial designations, to be able to make sure that you're really taking the most advantage of any kind of tax implications that may come into play. And this is really the last, this is mistake number 7. One of the biggest things we see is failure for people to communicate their plan with their family or loved ones. Now, this doesn't mean you need to ask anybody for permission for what you're doing, but it's important on a couple of levels. Number one, you want to make sure anybody you've asked to be in any of the important positions under your estate plan, let's say we're talking about a trustee, someone who's going to be your personal representative, certainly someone you've asked to be your attorney in fact under a power of attorney, or your healthcare decision maker under a healthcare proxy. You want to know that they're going to be willing to take on these positions. The last thing you want is to be in a situation in which you don't have competency to manage your finances anymore, and the person you asked to do this for you says, I don't want to touch it with a 10-foot pole. Not my problem. Not going to do it. So it's important that you have communication with them to make sure that they're willing to be part of this, that they know what you've asked them to take on for you. The other thing is that it's important that they have at least some idea where to begin with things. For instance, most times we all have either a drawer in our house or some place where we keep important documents. You want to make sure that someone who you've asked to be the trustee of your trust, to be your personal representative or your power of attorney, knows where to start. How do they know where to find out where your bank accounts are, etc.? Where to find out where your assets are held? They can't do their job unless they know where to begin. Someone who you've asked to be your healthcare proxy, it's absolutely critical that you have the conversation with them about what you would want to have done if you can't speak for yourself in a healthcare crisis. You're asking them to step into your shoes, so they need to know what you would want to have done in this particular circumstance. Another thing that we find important in terms of family communication is that, particularly if your plan maybe does something a little different. Let's say you have decided to leave a specific asset to a specific person, one of your children. You have a loved one who needs to be able to continue to live in a property should you pass away before them, and to have that taken care of. To make sure that other individuals involved in the family have some idea that this is going to happen can really help to avoid any kind of crises or family discord after you've passed away. Now, again, this isn't asking permission. You don't have to ask everybody whether it's okay that you do, A, B, and C. But oftentimes, if you can have communication about why you've decided to do that ahead of time, it can really help to smooth things out, or at least give people an idea that this was done for a particular reason. Now, that doesn't happen always. There are times that, we choose to not include specific people in our estate plan, and we all have differing reasons for that to happen. With that, you want to make sure that your plan purposefully omits somebody, so that there's not a question that this was done by mistake. Now, you don't have to in your will say why you're not providing for one of your siblings or why you're not providing for one of your children, but you do need to state that you are choosing not to do that, to make sure that it's clear and that doesn't cause any kind of legal conflict afterward, where someone can say, hey, wait a minute, I was just forgotten, that they didn't mean to leave me out. So this is something that if you do have a reason to particularly want to exclude someone in your estate plan, that you talk with your estate planning professional to make sure that it's done properly to help to avoid any kind of issues after. You know, after you're gone, hurt feelings can happen. It's funny, we laugh a little bit, but you know, sometimes families argue about the smallest things. And the more we can do to kind of help to make sure that the plan is known, that everyone's on board with that plan ahead of time, the easier it can often be when otherwise people have high emotions happening with the loss of a loved one. So having family communication, making sure your wishes are well known, particularly those around what your healthcare wishes are, what your wishes are for your finances while you're alive, and who's going to manage that for you is critical to make sure your wishes are followed, your plan is followed, and to help to kind of allay any kind of discourse after your passing. So, quick recap, the 7 mistakes that we talked about in terms of trying to make sure that you avoid as much as you can ahead of time, that you look at your estate plan on a regular basis, make sure your beneficial designations are up to date, make sure that you understand how your assets are flowing, and if you have a trust, that you have thoroughly funded that to the greatest extent possible, so it's doing everything that you can want it to do, that you've looked at tax considerations with both your estate planning professional and you know, your accountant if you have one, and certainly with your financial planning professional is critical. Remember that estate planning is not just a one and done. It is something that's ongoing, and it should be looked at and revised as things in your life change, as we continue to age, many different things, changes in our health status, changes in our family status, etc. Some of the things you can do right away. Look at those beneficial designations, make sure things are correct. Schedule something with one of your professionals, particularly this time of year as we're getting ready for taxes, and make sure that you're doing these reviews annually. Thank you, everyone. I don't know if there's any other questions that anyone has before we close down.
We have a couple questions in the chat, Kathleen. The
Mm-hmm.
first one is, can property be moved to a trust if it has a lien holder due to a mortgage or an HELOC still being open?
So a HELOC. So great question. Yes, in most instances, yes. When we're talking about moving it to a revocable or revocable trust, we can move property even though it's subject to some kind of mortgage or HELOC. When we're talking about property being moved into an irrevocable situation, then we have more of an issue. Basically what happens is when you make any kind of change to ownership in real estate, you risk when there's a loan against it, there's some kind of mortgage or HELOC against it, you might risk causing the clause in the mortgage that says transfer will cause you to have to pay this mortgage off to be triggered. And so we don't want that to happen, of course. So moving it to a revocable trust, a revocable trust does not trigger that clause. But an irrevocable trust might trigger that clause. And so it's something that you really want to take a look at with your attorney and say, are we able to do this? What's the consequences if we do?
Wonderful. The next question is, if the trust was established to avoid mass estate taxes, what happens if it holds more than $2 million?
So if I'm the first to die of a couple, then what happens is we are limited to no more than 2 million that we can get when the first of a married couple dies in terms of protection for from the estate tax issue. Anything above that, and again, it depends on how the trust is written, typically funds what we call the marital trust portion of the trust, and will still be there for the benefit of the survivor, but is added to whatever the survivor has on their side at the time of the death of the survivor. So let me give you an example. Let's say there's $5 million in a trust. This is a husband and wife who own this trust together. It's a joint trust. One of them dies, and about half of it, or 2.5 million, is now going to be earmarked and put into sub-trusts that are created by the initial trust. One of those trusts is going to hold up to the $2 million. We have $500,000 extra, and then we have the other 2.5 million that's sitting over here with the survivor. All of it's for the survivor's benefit, but when the survivor dies, the 2 million will not be counted against them from an estate tax standpoint, but the 2.5 that they have and that $500,000 extra will be, or 3 million will be considered for estate tax purposes. So we will have an estate tax on 1 million of it, or about $100,000. Where if we didn't do this planning and all 5 million went to the survivor when the first died, we would have $3 million subject to the estate tax, or about a $300,000 bill. So we don't eliminate it in that case, but we reduce it.
Thank you. Another question. How, what is the best way to not have assets be part of a Medicaid review when a loved one is in a nursing home and money is running out? Is the trust the best vehicle for this?
So that's a much more complicated question. Depends on the type of trust. So remember, a revocable or revocable trust, it's a fancy way of holding your assets while you're alive. And that is going to be subject to a spend down because it's yours. It's your asset. However, an irrevocable or irrevocable trust is oftentimes what we use to be able to take assets out of your control so that they're not subject to spend down if you need to go into a nursing home. But there are many, many rules around that type of trust. One in particular is it's subject to the 5-year look back, which means that you have to have put this trust together and funded it at least 5 years before you apply for any kind of state assistance. And you have to remember you're giving up things like control over that asset and use of that asset in many circumstances. So we can use trust as a way of being able to protect assets, but you need to have the right type of trust, and you need to make sure you understand what the consequences are of putting assets in that type of trust.
Thank you. One more question. Can you take money out of a trust if investment earnings made the value higher than expected?
Well, remember, if it's a revocable or revocable trust, then you have control. You can take money in and out of that trust anytime you want to. It's as if you own the asset yourself. I say to clients, it's just a fancy wrapper, and the purpose is to avoid probate and in some instances to help to reduce estate tax exposure. So you absolutely have control during your lifetime over those assets in any way you want to. Now, after the death, if it's a jointly held trust between a husband and wife, after the death of the first of you, there are restrictions oftentimes on how some assets are held. And certainly if it's an irrevocable trust, or this is a trust that was created by somebody else and funded by somebody else, and you're now a beneficiary of that, there may be restrictions on what you can do with that money and what your access is.
Wonderful. Well, I don't see any more questions in the chat. Are there any more questions? Joan, I believe we do have a question.
Yeah, hi. We didn't talk about, I'm sorry, the step up in cost basis. And sometimes people forget and they automatically put their child's home, their home in their child's name. And did you want to talk around that? Because I've heard that that's a mistake that people make, and then it's they don't get the advantage of the step up in cost basis because
So
they're now the owner.
so
And
Joan, I'm so sorry, Joan. Excuse me.
that's okay. I'm sorry.
Oh, no. So you're saying, a mistake being that people say, hey, I want my child to have my house. And so
Right.
they just go ahead and transfer ownership of the house directly to their child, or they just put their child's name on the deed. And you're right, that is absolutely has potential issues in the future. One being that you lose what's known as a step up in tax basis oftentimes. So let me just give a quick explanation of that. So let's say, you bought your house back in the 1960s. I joke that my parents bought their house for what I can't buy a car for anymore, about $18,000. And now, fast forward, and that house is now worth $800,000. So if my parents still lived in that house, if they went to sell it, they're going to pay capital gains potentially on the difference between the 18,000. Now, there are things we can add to that. Like they put a new kitchen on the house, they put a new roof on the house, blah, blah, blah. And let's say we could get that cost basis up to $100,000. So now they go to sell the house for $800,000. There's $700,000 in capital gains. Now they live in the house, presuming both my parents were still alive. They each get a $250,000 capital gains exclusion, or $500,000. So they're only paying capital gains really on $200,000 from that sale. Now, let's say my parents said, well, we really want Kathleen to have this house. And so they gave me the house. So they put my name on the deed. Well, after they've passed away, if they do it that way, and I don't live in the house, I live elsewhere, and I go to sell the house, I don't have the same exclusions that they had because it's not my primary home. Now I potentially have a $700,000 capital gains in that example I just gave you. So what Joan was alluding to is there are other ways of being able to transfer a house to a child. One is what we call a life estate. And there may also be ways like with an irrevocable trust situation to be able to transfer a house so that for tax purposes, the original owners remain the owner of the property and are able to claim the exclusions that they get, or the property gets a full step up in basis so that, again, if my parents, instead of giving me that house while they were alive, left it to me as part of their estate, or gave me the house with what's called a life estate deed, then I would actually get the house at whatever it was worth when they died. So now I turn around and sell it. If I sell it within a reasonable period of time after their death, I may have no capital gains. So wonderful point, Joan. And it's something that people have to be very careful about when they're thinking about giving. You would think, oh, isn't that wonderful? They're giving this house to so-and-so but there are tax consequences that they need to take into consideration.
You're welcome.
Thank you.
All right. Any more questions? I think we are good. Thank you again,
Wonderful.
Kathleen. That was a wonderful presentation. I know I learned a lot, and I always do.
Thank you, Alex.
I wish everyone a happy afternoon.
Thank you, everyone. Take good
Thank
care.
you.
Bye now.